Hello students, welcome to the Recitals in-depth. In this session, we are going to discuss the important topics that are featured in the section of Polity and Governance for the month of May 2024. The topics that we are going to cover are broadly following under the themes of Parliament, Elections, E-Governance, Local Governance. So now let's take a look on the topics that we are going to cover in today's discussion. So we have with us a lot of interesting list of topics which are featured in the month of May 2024. And while during the course of the discussion, we are going to follow a very unique approach that we are going to break down every topic to get down into the deep layers of the concepts which is involved, and then we will be equipped to answer any question which might appear in the examination. Now, let's come to the first topic for today's discussion, that is Eggshell Skull Rule. From the name, it is quite evident that the name seems to be quite abstract in nature. And the image that we have used, you can actually very well remember that there was a nursery rhyme by the name of Humpty Dumpty. Humpty Dumpty sat on a wall, Humpty Dumpty had a great fall. How this Eggshell Skull Rule, which is a legal doctrine used by the judiciary, not only in India, but across the world, and how we are going to utilize this nursery rhyme to actually understand the concept of Eggshell Skull Rule, this is what we are going to discuss in the next slide. So, we'll start the discussion with the context. So, what is the context and why we are trying to understand and learn this particular topic? So, recently, the Supreme Court of our country provided a judgment. In the judgment, it provided that the National Consumer Disputes Redressal Commission and the State Consumer Dispute Redressal Commission of Himachal Pradesh, they basically incorrectly applied the rule of eggshell. Now, before we go on and discuss what was that particular case in which the Supreme Court mentioned that these organizations, that is the National Consumer Disputes Redressal Commission and the State's Consumer Disputes Redressal Commission incorrectly applied the legal principle or doctrine of Eggshell Skull Rule, we will first try to understand what is this particular concept which is known as the Eggshell Skull Rule and how did it origin in the world. What was the need which basically necessitated the emergence of this particular legal doctrine. Now, to begin with the first question, that is, what is Eggshell Skull Rule? So, this is nothing but a legal principle. Legal principle which is applied in civil litigations. And what are civil litigations? Civil litigations are such kind of disputes where the contesting parties, they seek monetary compensation for the damages which have been occurred. So whenever there is any kind of dispute, whether it be civil dispute or a criminal dispute, there will be two set of parties. One will be a wrongdoer, a person who has committed a alleged crime, and another a person will be a victim. So this Eggshell Skull Rule is usually applied in cases of civil litigation, and examples of such kind of civil litigations are, for example, medical negligence. And for your information, this particular case that the Supreme Court was also dealing with the case of medical negligence only. It was a civil suit or a civil litigation. And one of the primary component of a civil litigation is that the contesting parties, they demand for monetary compensation. Monetary compensation for the whatever the wrong has been conducted on the victims. Now, from where does this eggshell skull term comes? So, as the name suggests that the egg is quite brittle in nature. Do you remember whenever in earlier when we used to get eggs from the market? So, we used to be very careful while traveling with those eggs because any kind of jerk or even a feather touch is there, it might be a possibility that the eggshell might break since it is so brittle in nature. And that is what the philosophy or the etymology of this term is, which has been actually juxtaposed in the emergence of a legal doctrine by the name of Eggshell Skull Rule. So what does this Eggshell Skull Rule actually says? It essentially says that the wrongdoer is liable for all the injuries. For all the injuries which has been inflicted on the victim, and these injuries are overly enhanced because of the pre-existing situation or pre-existing condition with respect to the victim. Now, to understand it, we will be very well able to understand it with the help of an example. Now, assume this particular case, and in the same way, we will be trying to use the nursery rhyme, the image that we have provided in the first slide. So, now let us imagine, now there is a person who is a wrongdoer. He committed certain act or certain activity which basically aggrieved the victim. So, the victim approached the court. Now, let us try to understand this eggshell skull rule with the help of this particular example. Now, imagine this victim is named as X and this aggressor or the wrongdoer is named as Y. Now, in a moment of fun only, these two are friends, and this person Y, he basically kicked the person X. But the Y was not aware that the person X is having a pre-existing condition, that basically that person X is having such kind of medical condition that his bones are quite weak. And when Y kicked the X in a moment of fun or in a moment of play, ultimately it related to very aggrieved or enhanced medical condition for the person of Y. And because of that, X went to the court in a civil litigation where he demanded that ultimately Y has to pay for all the injuries that have been provided to the X, and X demanded for an enhanced compensation. X demanded for an enhanced compensation. And naturally the person Y would feel that since the strength of the kick was so small or so low, ultimately it was the fault of the X or the pre-existing condition which the X was having. This pre-existing condition led to such enhanced injuries to the particular person, and since the pre-existing conditions were there, the particular person Y does not want to take the responsibility of it, and that is where the emergence of eggshell skull rule takes place, where the eggshell skull rule says that in the eyes of the law, it does not matter whether the person X had a pre-existing medical condition. What matters is whether the action of the Y person or the person who's named as Y was lawful or not. And if the action which the Y person had committed is unlawful, then according to the doctrine of eggshell skull rule, the Y person will be liable to pay all the compensation and the enhanced compensation for the enhanced injuries which were imposed on the X. Now let us try to understand it with the nursery rhyme that we had quoted. So, as we know that Humpty is an anthropomorphic egg. What is we mean by anthropomorphic egg? So, basically anthropomorphic egg means that Humpty is a fictional character who is an egg but a humanized egg. So as we see in cartoons, so these kind of things are very attractive to the nursery going students or very small children. So Humpty is an anthropomorphic egg, and we already know the characteristic of egg, which is it is quite brittle. So one day what happened, that Humpty was sitting on a wall, and this wall was basically managed by the local government. Okay, the wall was created by the local government, and Humpty is quite light as he is just an egg and he is quite brittle. So even when Humpty was sitting on the wall, ultimately what happened, the wall broke, and because the wall broke, Humpty fell down. So Humpty had a great fall, and because Humpty had a great fall, what will happen when an egg will experience such a fall? It will definitely break. So it broke the skull of Humpty. And that is the emergence of the legal doctrine of eggshell skull rule. Now Naturally, when Humpty went to the court and Humpty told that because the wall was so weak, when I sat on the wall broke down and it eventually led to the breaking of my skull. So the local government, who was the defendant in that particular case, the local government was of the opinion that the problem is not with the wall. Okay, the wall was weak, but since you had a pre-existing condition, that you are so brittle, that is why you are being injured in such a grave manner. So that is not the responsibility of the local government. And through this analogy emerged the doctrine of eggshell skull rule, that in the eyes of the law, it does not matter what kind of pre-existing conditions a particular person is having. If there is a particular act which is done and which is unlawful and it is resulting into any kind of injury to a particular person, so the defendant party or the party who is doing the wrong action is liable to pay enhanced compensation to the victim. So in the eyes of the law, it will be the responsibility of the wrongdoer to pay the enhanced compensation. And that is the primary pillar with respect to this eggshell skull rule doctrine. And similarly, with coming to the emergence and origin, now as we understand the core philosophy behind the emergence of such doctrine, it will be very easy to understand the origin of this doctrine. So this doctrine originated in the country of USA in the year of 1891, where similar kind of situation happened. There were two friends in a classroom by the name of Wasberg and Putney. So there was a case that Wasberg was having a pre-existing medical condition of osteoporosis, that Wasberg was having a case where his bones are quite brittle. And what happened, that in a fit of play, Putney, who was his classmate, he kicked Wasberg. And what happened, that Putney was not aware that Wasberg was having such kind of medical condition. And what will happen when Putney will kick Wasberg? That naturally Putney developed a severe injury in his leg. And what happened, that because of the injury that had been caused by Putney, ultimately Wasberg became lame or disabled. So this basically aggrieved Wasberg and he approached the court, and the court was Wisconsin. It was a city in United States of America. So they approached the Wisconsin court, and in Wisconsin court, while the judge was hearing it, they held that it does not matter whether Wasberg was having any pre-existing medical condition or not. What mattered in the eyes of the law is that how did the law find the victim over there? It does not matter that the Wasberg was having any kind of pre-existing medical condition of osteoporosis. What mattered is that whether the action of Putney was lawful or not. And since Putney did an unlawful act, he will be absolutely liable for all the damages which he has to pay. In normal condition, had it not been Wasberg and a normal person who is having a normal bone structure, if Putney would have hit that particular person, there would not have been any kind of injury. But since Wasberg was having a pre-existing medical condition, Putney was liable for all the enhanced conditions or enhanced compensations which will be required to actually nullify all the wrongs has been done to Wasberg. And this led to the emergence of eggshell skull doctrine in the year of 1891, and this particular doctrine has been transposed in various judiciaries of the world, and every judiciary tries to apply this particular legal doctrine in settling the issues of compensation in civil disputes. Now let us try to see what is the case in hand. What kind of case are we looking for? So the whole point is, as we know that the Supreme Court basically told that the state and the National Consumer Disputes Redressal Commission, they applied the eggshell rule in an incorrect form. So what had happened, that in the year of 2005, one woman who belonged to the state of Himachal Pradesh, she was constantly having a feeling of very chronic and acute stomach pain. So when she went to the hospital, a private hospital in Himachal Pradesh, so they found out, the practitioners or the medical professionals over there, they found out that she was having appendicitis. So they basically operated her appendicitis and removed the appendix portion. It is a very common medical exercise which is being carried out through our country. So what had happened is that even after the operation was conducted successfully, the woman was complaining for pains, and she approached the hospital again, private hospital, from where she had get her operation done. So as the pain continued, the hospital told that the hospital gave them certain painkillers, and then they convinced the women that the pain will be gone. However, the pain continued for 4 more years till 2009. And what had happened is that the woman was fed up with the private hospitals in which she had initially was admitted. So she went to Chandigarh in a very famous hospital, government-run hospital, and there in that hospital it was found by the medical practitioners over there that a 2.5 centimeter needle was left in her abdominal cavity by the medical professionals of the private hospital of Himachal Pradesh. So it becomes a very potent case of medical negligence. And what had happened is that the woman was so aggrieved due to the mental and physical agony, pain and anguish that she basically approached the District Consumer Disputes Redressal Forum, and the District Consumer Disputes Redressal Forum basically provided women a compensation of 5 lakh rupees. The women told this particular District Consumer Redressal Forum that this 5 lakh rupees is quite less. However, the private hospital was not happy with such kind of decision, since a private hospital will be liable to pay 5 lakh rupees. So it approached the appellate authority, which is State Consumer Disputes Redressal Commission. So State Consumer Disputes Redressal Commission, it basically decreased the compensation to 1 lakh rupees. Ultimately, the women was not happy. They approached the National Level Consumer Disputes Redressal Commission. It increased it to compensation to be 2 lakh rupees. The women was so aggrieved that ultimately the civil litigation led to the Supreme Court of India. And if a civil litigation is led to the Supreme Court of India, you can imagine the kind of fervor or the spirit the particular woman who is involved in this case has shown in this particular situation. So what Supreme Court found out is that Supreme Court found out that the kind of exercise or application of the eggshell skull doctrine which these agencies, especially the district and the state agencies, had put forward, Supreme Court found out that there was an incorrect application of the doctrine or the legal principle of eggshell skull rule. And Supreme Court told in this case that since the woman was facing the pain or the anguish because of the needle which was left in her abdominal cavity, it is not happening because of an pre-existing conditions. So Supreme Court identified that in the case of this particular woman, there was no pre-existing condition in this case, and hence there was no criterion for application of enhanced compensation based on the eggshell skull rule. However, for what Supreme Court provided the judgment in a more magnanimous and a more empathetic manner. So Supreme Court basically restored the compensation of 5 lakh rupees which was provided in the first leg by the District Consumer Redressal Committee or Commission, and it also asked the private hospital to provide for all the interest throughout the years. Now, so with respect to such kind of legal doctrines having such kind of unique and abstract names, what we can expect from the UPSC, that UPSC can ask a very beautiful question in the prelim examination. They can very well simply frame a very simple and a unique question that they will ask that what do you actually understand, or which of the following definitions given in the options best defines the eggshell skull rule. So I hope this explainer will be able to help you attempt such questions. Now, the next topic that we are going to discuss is a very important international organization by the name of Commission for Population and Development. Why we are trying to study it? What kind of importance does it hold for us for the examination? Let's check it in the next slide. So, what is the primary context behind why we are trying to understand and learn the Commission for Population and Development? So, what had happened is that recently in the month of May, the elected women representatives, now we'll call it EWRs, of PRIs, that is Panchayati Raj institutions, they participated in the 57th annual session of the Commission of Population and Development. What was the important theme of that particular session? So it had a very interesting theme. The theme was localizing SDGs. Localizing SDGs. SDGs are the Sustainable Development Goals. And localizing SDGs, women in local governance. So, from the theme, it is quite evident that the Commission for Population and Development, it has tried to merge two very important aspects for the global developmental landscape. Firstly, it is talking about localizing of the SDGs, and secondly, it is talking about what kind of role does the women are playing in the local governance, which might lead to localizing of the SDGs. So, from the examination point of view, we need to understand three very important points while studying or learning this particular topic. So, the first is, what is actually CPD, that is the Commission on Population and Development, when it was formed, what is its agenda, who formed it, etc. And the second important thing that we need to understand comes from the theme itself. So, we will be understanding the role of women in local governance and what kind of change in the local governance landscape are the women of our country are able to bring in, what kind of values and what kind of decision making styles the women or the elected women representatives who are representing their smaller panchayats or villages, what kind of value systems they are bringing in to the governance of the entire country. And thirdly, the third important point that we need to discuss is, what do we actually understand by localizing SDGs? As we know that the entire global community is following the Sustainable Development Goals, but what do we understand by the term localizing SDGs? There can be a very simple question again in an MCQ or especially in the GS2 mains, that they can ask us such kind of questions, that what do we actually understand by localizing SDGs. So before we go on and discuss the role of women in local governance and what do we actually understand by localizing SDGs, firstly, let us briefly try to discuss what do we actually understand by Commission on Population and Development. So all the details that we are going to study for Commission on Population and Development can be asked in the prelim examination. So this Commission on Population and Development was established by the UN specialized body, that is the Economic and Social Council. In short and famously, it is known as ECOSOC. So it was established by UN's Economic and Social Council, or in short ECOSOC, in the year of 1946 with an agenda of that it will monitor, assess and review the implementation of a very important document by the name of Action Agenda of International Conference on Population and Development. Now, when this particular body, that is Commission on Population and Development, was formed in 1946, it was usually known by the name of Population Commission only. In 1946, it was known as Population Commission only. However, in 1994, a landmark global workshop was conducted, and by the name of International Conference on Population and Development, which basically worked on two agendas. Since it was an international conference on population and development, it primarily worked on two major agendas. Firstly, how to balance the population growth with respect to the developmental aspirations of our society or the global community. How to balance the population growth with the developmental aspirations, first of all, because population growth requires a lot of resources, and resources are always in scarce, and governments face a lot of problem while dealing with huge amount of population and to provide very good developmental facilities as well, which is a very important case for our country as well, that since India is having a lot of population, the government of India finds it extremely difficult to provide such kind of developmental facilities, whether be it infrastructure, whether be it health, etc., to its large population. So this particular conference, that is International Conference on Population and Development, it deliberated how the global community should balance its goals of population growth, and on the other hand, how it should provide its population with proper development and facilities. And secondly, it held that, this particular conference held that the human rights and dignity should form the nucleus for the sustainable development. So ultimately, the development has to be sustainable only if the human rights are restored and the dignity of individuals are cherished. And there is no point of going for any kind of development which for the global community it might appear to be a development. However, if it is jeoparding the human rights and the dignity of individuals. So these are the major important points which is relevant from the examinations point of view, and it can be asked in the prelim examinations. However, now let us come to the more analytical point, which is we'll first try to understand that we had already discussed that what kind of role does women play in the local governance. As we know that the 73rd constitutional amendment, it brought in the Panchayati Raj institutions in our country. It provided a constitutional status to the Panchayati Raj institutions in our country. And one very monumental provision in the 73rd Constitutional Amendment Act was that it provided for 1/3 of reservation for the women. 1/3 reservation for women. And down the line, 30 years have passed since we had brought in the 73rd Constitutional Amendment Act, and we'll be very happy to know that roughly, according to the latest estimates, almost 1.45 million elected women representatives are participating in the day-to-day governance of the panchayats. And it is such a monumental feat for a democracy like India that almost 1.45 million, that is 14.5 lakhs of women are participating in day-to-day governance, shaping the policies which is required at the local level, identifying the priorities which is required for the development of that particular region, and also working on the gender front as well. So whenever women or the elected women representatives are positioned in decision-making roles, it does not only lead to empowerment of women alone, or it does not only lead to just delivery of governance. Whenever a woman is positioned in a very important political political structures, and women is having the political say or the political representation, it has very wide spreading effects, not only for that particular community but for the entire political structure and political system of our country. So for example, whenever the women are represented in decision making roles, they work for the gender equality. They will provide for more effective and good governance. They will alter the asymmetric power structure which is existing. Asymmetric power structure which is existing in the society with respect to the gender. And ultimately, it will result into deepening of our democracy as well. Deepening of our democracy as well. And as we already discussed, the theme of the 57th session of CPD was localizing SDGs and the role of women in local governance. So it basically merged two very important developmental concepts. That is, first of all, the women in local governance who are participating in the local governance and how they are leading to the localizing of SDGs. So as we know that whenever a woman is in the position of taking decisions, it has research suggests that women take decisions keeping community in the mind, keeping their children in the mind. And it has been observed through various researches that whenever women are involved in the political processes and in the administrative systems, these systems have been found to show lesser of corruptions. And And that is why it is very important that we need to have more and more women participants, because they not only bring in different value sets, they bring in different principles and approach into as in how to approach a particular problem and to decide what does that particular community wants, and women of that community are the primary recipient or knowledge bearers or the entire or the basic need and aspirations of that particular community. And when these women who know their entire community well, their aspirations and needs well, when they come into the political structures, they design the policies and schemes and plans in such a manner which leads into very, very delivery of good governance, and ultimately it changes the social and political landscape in that particular community. Now, let us try to understand what do we actually understand by localizing of SDGs. Now, as we know that the Sustainable Development Goals have been designed by a very international or a global body. Now, it might not be a case that whatever like the persons or the policy makers who are creating policies for the entire global community, it might be a possibility that these SDGs might not be able to fit in for the local demands and aspirations which a village has. And that is what we understand from the term of localizing SDGs, that is toning down the SDGs or taking the idea of the SDGs and trying to merge it with local aspirations and needs of that particular community. So localizing means that there has to be a fusion. There has to be a fusion with the idea of SDGs and how it is actually translated into a very say remote village in any very remote part of our country. So that particular village or that particular panchayat should be able to translate or map their particular needs and aspirations to what the global community wants to achieve with the help of the SDGs. So the framework or the idea of the SDGs should be translated and should be matched with the local aspirations and needs of that particular local community or a village. And how we can actually achieve it? So as we know that these are the proper 17 sustainable development goals which has been cherished by the global community, and these are some of the list items which are mentioned in the 11th schedule. What is 11th schedule of our constitution? 11th schedule of the constitution provides for the list of subjects on which the local government or the Panchayati Raj government has power on. Now, ultimately, in essence, the localizing of SDGs mean that in whatever list does the local governments can legislate or can regulate affairs, they should be able to map in the sustainable development goals. So for example, let us try to understand with the help of very few examples which has been listed in the 11th schedule. So for example, the first SDG is no poverty. So the SDG says that there has to be no poverty till we achieve the time of 2030. Now, if we'll go through the certain entries which have been provided in the 11th schedule, so the first entry in the 11th schedule is poverty alleviation. So we need to see that SDG is also demanding no poverty, and the 11th schedule is also asking the Panchayati Raj government to create such plans and schemes that there has to be a poverty alleviation. Now it is up to the various stakeholders to decide that how they are going to actually implement the goals which has been provided by the SDGs and how is it getting correlated with the subjects which are listed in the 11th schedule of the constitution. And since India is on a very rapid path of economic trajectory, and India is actually increasing its developmental parameters, whether it be socioeconomic parameters or political freedom parameters in a very fast manner, it is of utmost priority that our policy makers and our administration and the key persons in the decision making architecture, they should focus on localizing the SDGs and to leverage the power of the Panchayati Raj organizations to actually conceive and design such plans which can be implemented to actually cater to the needs and aspirations of the local community. Now, as the elections are underway, series of news started pouring in alleging Prajwal Revanna, who is a member of Janata Dal Secular Party, about a very series of like sexual harassments and sexual abuses allegations against this particular person. And in no time, Prajal Ravanna fled the country to Germany on his diplomatic passport. So he particularly used his diplomatic passport to flee to Germany. So what we need to understand in this topic from the examination's point of view is that what is this particular diplomatic passport? What kind of passports do our country already have? And why did he flee to Germany? Why not any other country? Or what other countries he could have flown to? So let us try to understand it in the next slides. So what do we actually understand by the term passport? So passport is nothing but an official travel document which is issued by the government of any particular country to its citizens. So that, what is the purpose of this particular travel document? So that this passport will be able to identify the nationality or the identity of that particular person while going for international travel. Now, usually these passports actually comprises of a lot of details. For example, it holds your photograph, it holds your name, father's name, your date of birth, its expiry date, etc. Now, the similarly used term is visa. And there is also an important term by the name of visa policy. So what is visa? So visa is again an official document which is provided by a country, and it basically allows entry to a particular country. It allows entry to a particular country and under certain conditions. So for example, based on the conditions, the visa can be of various types. For example, as we already know, one of the most crucial visa which is always in news is the H-1B visa. H-1B visa, which is provided by USA. However, H-1B visa is a work permit visa. So based on the conditions, it defined who can enter the particular country or who can enter USA in this case. And secondly, what are the activities for which they are being allowed to enter that particular country. So based on the conditions of entry, it can be student visa, it can be a travel visa, it can be a labor visa or a work visa. Okay. So these are the major important aspects with respect to the passport and visa. Now, what is a visa policy? So usually visa policy is a bilateral agreement. It's a bilateral agreement between various countries or between two countries which define that what categories of individuals can enter any particular country. So for example, there might be a bilateral agreement between USA and Canada for an example, that there is a bilateral agreement or a visa policy between USA and Canada that the citizens of Canada or US do not need visa to actually travel to other country. And such kind of agreements or bilateral agreements between different countries are known as visa policies. Now let us try to learn about various kind of passports which are being issued by our country, so that we will be able to understand what is a diplomatic passport. Now, the primary legislation which is governing the regulation of passports in our country is the Passport Act of 1967. So the primary act is the Passport Act of 1967. Under section 3 of this particular act, it provides for a provision that no individual can travel outside of a country or can take an international trip without having a passport or an official document. So no individual can travel abroad if he is not having an passport or valid travel document. So from this thing it means it is quite evident that Prajwal Ravanna, when he had fled the country to Germany, he definitely must be having his passport along with him. However, one very important facet that we need to note over here is that what had happened is that when Prajwal Ravanna, since he being a very important and very big political leader of big stature, so definitely it created a ruckus in the society and people started asking questions to the MEA. That is Ministry of External Affairs, and MEA in its press conference it told that the Prajwal Ravanna was not issued a visa to travel to Germany. So how was it possible that Prajwal Ravanna was able to flee to Germany without having issued a visa? So can it be possible? There is one condition that it might be possible that we already studied, that India might be having a visa exemption agreement with Germany that we are going to discuss in the coming section. However, coming to the Passport Act of 1967, Section 3 provides that if a person wants to travel abroad or beyond this country, he must be having a passport. Secondly, the Section 4 of the Passport Act of 1967, it provides for various classes of passports which is issued by the Indian government. The passports are issued by the Indian government based on the functionalities, what kind of functions that that particular passport holder is going to serve, and secondly, the status of that particular individual. Now, based on the Section 4 of the Passport Act of 1967, Indian government is actually releasing passports of these 4 categories. Now, this having a dark blue cover is that we call as the normal passport. Normal passport, and it is issued to normal citizens of our country for the purpose of their personal travels. As simple as that. Secondly, and one important facet to note over here is that it is issued for a timeline of 10 years for adults and 5 years for minors. Minors are the persons who have not reached the age of 18. Now, this white passport, which is written over here, that is the official passport. It is known as the official passport, and it is being provided to the government officials who usually travel outside India for conducting of the government's business and who do not fall into the services of Indian Forest Services or are not associated with Ministry of External Affairs consular services. Again, this official passport is also valid for a timeline of 10 years for adults and 5 years for minors. Now, coming to this orange passport, this is the third category of passport. This is also known as emigration passport. Emigration passports are meant for those individuals or those Indian citizenry who are looking for employment prospects outside India. So there are 2 conditions. Who are looking for employment prospects outside India, and secondly, who have not finished their formal education. That is, they have not finished their education till 10th. Again, the time period associated with this orange or emigration passport is 10 years for adult and 5 years for minor. Now, ultimately, the elephant in the room, that is the diplomatic passport through which Prajwal Ravanna fled to Germany, and definitely since he actually fled to Germany without having been issued a visa, so definitely this diplomatic passport comes with a lot of status symbol and comes with a lot of privileges and immunities as well. And this is what we are going to discuss in the coming slide. So what is this diplomatic passport? So as different from our normal passport which had the dark blue outer cover, this diplomatic passport is having a maroon cover, as it was evident from the image which was shown in the previous slide. So it is having a maroon cover, and it comes with a great degree of immunities and privileges. Comes with a great degree of immunities and privileges along with a social status And since it is such an important passport which is being issued by the government of India, so it is very sure and it is quite evident that it is not being issued to any and every individual of our country. So what is the category of persons for which these passports are being issued? So according to the Passport Act of 1967, these passports are being issued to primarily 4 kind of officials. Firstly, it is being provided to people with diplomatic status. Secondly, it is being provided to the officers of branch A/B, A or B branch of Indian Foreign Services, usually of the rank of Joint Secretary and above. Apart from it, it is also provided to the immediate family members. Immediate family members of the staff of Indian Foreign Services and Ministry of External Affairs. And lastly, to certain select individuals who has been appointed by the government, to take more frequent international travels to conduct the business of the government of India or the respective state governments. Example over here in this category can be the chief ministers of the states, the MPs, members of parliaments, or certain MLAs as well in certain cases. However, MLAs usually do not have much work of the international nature. However, the MLAs also visit many kind of international conferences in various countries, and that is why such kind of passports are also issued to such political functionaries as well. Now, as we already discussed the various kind of categories of people for which the passports are being provided or the diplomatic passports are being provided, now what kind of benefits are being associated with it? So the major benefit associated with it is, first of all, their immigration process is quite fast-tracked. Immigration process is fast-tracked. That is, whenever you land into a foreign country, you don't have to wait in the lines, and ultimately by knowing the color of your passport, the custom officials which are present in other countries, they will be providing you a very privileged treatment. Second most important privileges and benefits of carrying such passport is that it makes the bearer or the holder of that passport immune from arrest in foreign countries, and it also makes immune from certain legal proceedings in the foreign countries. So it is such a great privilege for the persons who are holding the diplomatic passports. And thirdly, the visa exemption agreement. This is a very important point. Visa exemption agreement. If you'll remember, we discussed that Prajwal Revanna went to Germany, and then I had posed a question that why did Prajwal Revanna chose Germany only to flee? He could have flown to some other countries as well, but why Germany? So ultimately, and we discussed also about the visa policies, that the bilateral agreements between India and some other country. So the holders of the diplomatic passports are actually like being provided with certain visa exemption agreements. So India had signed a visa exemption agreement with Germany in the year of 2011, which provides certain immunities and facilities for the holders of diplomatic passport. What they can do under these visa exemption agreement is that under that agreement, it allows any bearer of diplomatic passport of India to stay in Germany without visa for 90 days. So they can stay in Germany for as much as 90 days. Similar kind of visa exemption agreement India has signed with other countries like France, Switzerland, Italy, etc. From examination point of view, you need need to mug up such other countries. However, what we need to appreciate over here is that there is a visa exemption agreement, and this visa exemption agreement is empowering the bearer of the diplomatic passport to go into such countries with which India has signed such agreements and to stay there till 3 months or 90 days. And last benefit of having diplomatic passport is the status symbol which it radiates. So it's a status symbol in our society as well, that people try to flaunt it also. Now, since the diplomatic comes with a lot of benefits, so definitely when you enjoy some kind of powers, it comes up with certain kind of responsibilities as well. And this is what we are going to discuss with respect to the protocols, and what kind of protocols does the persons who are having diplomatic passports are assumed to follow when they are traveling abroad. So the first point is that they need political clearance. Political clearance, that is, whenever a person is planning to travel abroad, not only for official purposes but also for personal purposes, and if they are planning to travel with the diplomatic passport, they should inform the proper authority, Ministry of External Affairs in this case, before traveling or before going on such international trips. And in this case of Prajwal Ravanna, who is an MP, so for such politicians, they should first take clearance, political clearance from MEA before traveling to some other countries. And in this case, Prajwal Ravanna failed to take the political clearances from the Ministry of External Affairs. And in this case, since he could not take the political clearance from the Ministry of External Affairs, a lot of resistance rose up in our country, asking various officials in the Ministry of External Affairs to actually nullify or revoke the diplomatic passport of Prajwal Ravanna. So let us try to understand the various provisions of the Passport Act of 1967, which deals with the revocation of passport. So Section 10, Clause 7 of the Passport Act of 1967, it deals with the revocation of passport. So the first point, it says that the authority or the competent authority, that is the Ministry of External Affairs, it can revoke the diplomatic passport or any passport in such case if the passport is in wrongful possession. So for example, if a diplomatic passport belongs to a person X and a person Y is carrying that particular passport, so the competent authority, that is the Ministry of External Affairs, will have the powers to actually revoke the passport of that particular person. So the first point is if it is in wrongful possession. The second important point to note over here is that the competent authority can revoke if it is found that the passport has been availed by providing misinformation or wrongful information. The third important point we need to note over here is that the passport can be revoked if it is found that the person or the bearer of that particular passport is being convicted for more than 2 years in any particular crime. Fourth point is that particular passport can be revoked if and only if court orders. For example, if any person who is sub judice and it is already there and his plea is already there in the court, then the court has to order the competent authority to revoke, and the central government cannot revoke the passport of that particular person if the case is sub judice in nature on their own suo motu. And fifth, the competent authority can revoke the passport if the competent authority feels that it is in the true interest of sovereignty and integrity of our country that the particular passport has to be revoked. So this is all for this particular topic. Now, as we recently concluded the general elections to constitute the 18th Lok Sabha of our country, there were major discussions going on in our society with respect to why does a candidate has to contest elections from more than one seat, since ultimately it will be not possible for the candidate to hold that particular seat if it wins from both the seats. So this is what we are going to discuss in this particular section, that is, what does the law says about the rules on contesting elections or contesting different seats. So before we go on and discuss the various important provisions of the Representation of People Act, firstly let us try to discuss what are the basic minimum eligibility qualification for a person to have so that he can actually contest an election, so that he will be eligible to become a member of parliament. So the constitution, under article 84 of the constitution, it provides 4 eligibility criteria. Firstly, that it has to be that particular person has to be a citizen of our country. Secondly, they should subscribe to an oath by the person appointed by Election Commission of India. Thirdly, they should be above age of 25 years and 30 years for Lok Sabha and Rajya Sabha respectively. And lastly, it empowered the parliament to create certain laws which will provide for further qualifications. So it gave the power to the parliament also to create certain additional qualificational benchmarks. Using this power, parliament formulated the Act of Representation of People Act 1951. In that, it provided 2 very important clauses. Firstly, it provided that any person who is actually qualifying these 3 criteria will be able to contest elections if that particular person is registered as an elector in any constituency. And secondly, that person, if he wants to contest a seat which is reserved for SC and ST, then he should fall into that particular category. So only a person who is falling into the category of scheduled tribe will be able to contest elections from a seat which is reserved for that particular class of individuals, that is scheduled tribe. Now, that is the constitutional and the legal framework which sets the basic premise of qualification or eligibility for a particular citizen of our country to participate in the elections of our country. Now, as this eligibility criteria is clear, let us try to understand what does the Representation of People Act of 1951 holds with respect to the contesting rules. So, the primary law or legislation which governs the regulation of contesting elections in our country is the Representation of People Act 1951. There are 3 various important provisions in this particular law which regulates the contesting of elections. First is section 4 of the RPA 1951. It provides that once the eligibility criteria which we already discussed in the upper half, if citizen is meeting that thing, then he can contest for elections. Now, under section 4 of this RPA 1951, it says that a person who is registered as an elector in any constituency in our country can contest elections from any constituency in the country. He can contest elections from any constituency in country except Assam, Sikkim and Lakshadweep. What does this proper section mean? So for example, if Rahul Gandhi is registered as an elector in the state of Delhi, but since he is registered as an elector in the state of Delhi, he can contest elections from any constituency in the country except these 3 states of Assam, Sikkim and Lakshadweep. There is another important section which is known as section 33 clause 7. This is a very monumental section and it forms the heart of this particular debate, that what is the proper number for which a particular candidate can contest elections. So, according to section 33 clause 7 of the RPA Act of 1951, it provides that a contestant can contest elections from a maximum of 2 seats. 2 seats. You will be surprised to know that this section, that is section 33 clause 7, was introduced in the Act of Representation of People Act 1951 in the year of 1996 through an amendment. And before this amendment, there was no bar on the number of seats through which a candidate can contest elections. So there had been cases in the past where people have contested from 3 seats. For example, Atal Bihari Vajpayee, he had contested elections from 3 seats in the second general election of 1957, and it is quite common for candidates to contest from 2 seats, as we have seen with the case of Mr. Narendra Modi, who basically contested elections from Varanasi and from Vadodara. And similarly, in this general election of 2024, for instance, Rahul Gandhi, he contested general elections from Wayanad and Raebareli. So ultimately, section 33 provides the power to the candidates to contest elections from maximum of 2 seats. This section was introduced by an amendment which was introduced in the year of 1996. Before that, there was absolutely no limitation on the power of the candidate to contest elections. So they could have contested elections from how many seats they would have wanted. And third important section which we need to note over here is the section 70. It says that, section 70 of the RPA 1951, it says that it does not matter that if a particular candidate is contesting elections from 2 seats. If he or she is winning 2 seats, then ultimately the election or the candidate, the winning candidate, can hold only 1 seat. And the winning candidate has to leave the second seat within 40 days of the election result. So ultimately, as soon as the winning candidate will leave 1 seat, and since it can hold only 1 seat, so this leftover seat will go for a by-election. And this redundant practice of by-election results into a loss of a lot of amount of public exchequer's money, financial resources and energy of the Election Commission of India. And secondly, since elections are a very competitive time for the Indian political system and political processes, elections generate a kind of almost tend to generate a kind of animosity and hate, and politicians thrive on that particular hate to win over the voters masses. So a particular, and whenever a candidate leaves their seat for a particular by-election, which means that the by-election will be contested in that particular constituency, and that particular constituency will be deprived of good governance since the election will be completed once again. And that is what there has been a debate in the society this time during the general elections of 2024, that ultimately there was a lot of demand by the people that we need to get away with the section 33 clause 7 of the RPA Act of 1951, since it results into a loss of money to the exchequer. Now, one very important criterion we need to focus over here is what will happen if a candidate is in jail. So 2 important things are there. Suppose, consider 2 important cases. Firstly, a candidate is in prison who is under trial. And secondly, a candidate who is in prison but is declared a convict. So what does the law says about these 2 important criterions? So you will be surprised to know in the 2024 general elections, 2 members actually won the elections while contesting from the jail itself. So there is one candidate by the name of Amritpal Singh, and there is one Abdul Engineer. And these 2 candidates won the elections while contesting from the jail itself. And the RPA Act of 1951 does not diminish their powers to contest elections when they are under trial, since they have not been convicted. Now, as soon as a person who is under trial and is convicted of, convicted of any kind of heinous crime of jail term of more than 2 years, then in that case, according to the Supreme Court 2013 judgment, their candidature for getting elected as an MP or an MLA, it gets vanquished then and there itself. It gets vanquished then and there itself. And ultimately, what had happened in the election of 2024, that there is a BJP member by the name of Ashwini Upadhyay. He approached the Supreme Court asking the Supreme Court to actually declare the section 33 clause 7 of the RPA Act to be invalid, since he put forward an idea that the democracy stands for the foundational principle of one citizen, one vote. and he advocated that this foundational principle, which is very valid and applicable to the citizens of our country, it should also be valid to the candidates of our country. And applying this particular principle, it should mean that one candidate should be given one seat. However, the Supreme Court did not entertain his petition and left the particular matter to the legislature to decide, since the Supreme Court felt that amending the section 33 clause 7 of the RPA Act is a matter of legislative policy, and Supreme Court will be doing injustice if it tries to actively involve in amending such kind of things. This is all for this topic. Recently, the Tamil Nadu government has made great strides in the field of e-governance and ease of living for the students of 10th and 12th by providing the facility of availing their report cards of the board examination in the portal of DigiLocker. And the same idea is poised to be introduced by the central government for the students of CBSE, that is Central Board for Secondary Education. So in this topic, we are going to deconstruct the topic of DigiLocker in its entirety. We are going to see what is actually DigiLocker, how does it function, what are the different stakeholders which are involved in this process, how secure it is, and ultimately what are the major issues which is grappling the functioning of DigiLocker. So let's start with the first topic, which is what do we actually understand by DigiLocker. So as you know, that DigiLocker is a flagship initiative. It's a flagship initiative by the Ministry of Electronics and Information Technology, which was launched in the year of 2015. And primarily it was designed to serve three major purposes. First is to empower citizens digitally, to empower the citizens of our country digitally so that they can store and access their important relevant documents. These documents can be anything. These documents can be your PAN card. These documents can be your passport or your board results, or can be your voter ID, etc. So it wants to empower the citizens digitally so that they can store their documents and access their documents at will at a cloud-based storage platform. At a cloud-based storage platform, and this is what we are calling over here as DigiLocker. So the first objective which it wants to accomplish for the citizens of our country is to empower them digitally so that they can store and access their important relevant documents so that they don't have to carry the documents everywhere that they are going, and it should be stored where? In a cloud-based storage platform, which is called DigiLocker. The second important objective which it envisages is to allow the issuer agencies. We'll deal in depth what do we actually mean by issuer agencies when we'll be discussing about the various stakeholders which are involved in the functioning of the DigiLocker. So the first point. Second point is that the issuer agency should be able to issue relevant documents and certificates. So for example, to make you understand this thing with the help of a very basic example, so just like Tamil Nadu Education Board had basically released or issued the board results for the students of 10th and 12th. So the Tamil Nadu Education Board becomes an issuer organization, and directly whenever the Tamil Nadu board is issuing the relevant results of the students, it is called the issued documents or certificates, which will be accessible to the students who have their legitimate signed in accounts at the DigiLocker portal. And third aim which it wants to achieve is that it aims to provide seamless authentication or verification by a third party organization. And this, what is this third party organization? Is this what we are going to discuss in the stakeholder section. And lastly, through the functioning of these three objectives in tandem, the DigiLocker wants to go into an era of paperless governance. So that the citizen of this country should not be bothering themselves about to carry the various relevant documents which are required at every stage in which they are either interacting with the governmental agencies or whenever they are interacting with any kind of private agencies also. So many a times we need to carry physically the various documents, and it can actually lead to sometimes theft or loss of certain kind of documents because of rain or adverse weather. So to come out of such kind of issues, DigiLocker envisages a paperless governance paradigm so that the citizens will be empowered and the processes which the government is following will be absolutely streamless. Now, what is the function of such kind of a DigiLocker if the relevant government authorities do not accept that these kind of documents which are uploaded over the DigiLocker are legal or not? So, Government of India has provided that under the IT Information Technology Act of 2000 and its subsequent rules, that the documents which are there in the DigiLocker will be treated at par or will be legally as valid as the physical document. So, just digitizing the transaction of the documents won't help. We need to create a holistic legal apparatus and an architecture which actually favors or treats the documents which are uploaded or stored in the DigiLocker at par with the physical documents which is belonging to a particular individual. So this is the core philosophy which is behind the operation and functioning of the DigiLocker. Now let us try to understand how does the DigiLocker functions. So it is extremely easy, and it has been shown diagrammatically over here. So any person who wants to use the DigiLocker, so first of all they need to download the application in their mobile phone. Secondly, they need to authenticate their own identity with the help of either Aadhaar number or phone number. And thirdly, they need to set up a PIN so that your data privacy has to be maintained and it is devoid of any kind of data theft. And lastly, as soon as the sign up is done, the issued candidate or any citizen who wants to use the DigiLocker app will be able to store and access any documents at their own will. Now, we need to understand the basic benefits which the DigiLocker is providing. So DigiLocker is providing benefits not only to the institutions but to the government and to other third-party organizations as well. And this is what we are going to understand with this stakeholder diagram. So ultimately, the stakeholders involved over here are the users who are using the various facilities which are being provided by the DigiLocker. Secondly, there are issuer organizations, just like we discussed, that is the Tamil Nadu Education Board is an issuer organization. There are many other issuer organizations, for example, Election Commission of India. Election Commission of India, while we were actually undergoing the general elections for the 18th Lok Sabha, Election Commission of India is also registered as an issuer organization in the DigiLocker. So what Election Commission of India can do is that they can issue the relevant elector voter ID cards in the user sign-in accounts of the DigiLocker so that the user can directly access whatever the issuer is providing. And the third important stakeholder over here are the requesters. So requesters are those third-party organizations which require our identity to be authenticated but without having the citizens to brought in the papers or the relevant documents in physical form. So what it does, or what the requesters does, is that it demands the various access to the documents which have been stored for an user's account, and as soon as the issuer and the users provide access to the requester will be able to authenticate the identity of the relevant user, and then the requester body will be able to provide the relevant services for which it was trying to authenticate that particular user. To make you understand this thing with the help of an example, suppose you are a user and the user's name is X. So for example, user wants to take credit from a particular bank. Let's call it as a bank. And there are many banks which are actually linked to the server of DigiLocker as well. So whenever we need to access some credit from the bank, so bank would definitely want us to authenticate our own identity. They would want to look into our PAN cards and our bank account details, etc. So we do not need to go to the requester or to the bank physically along with our documents. And that is the beauty of paperless governance, that with the help of a DigiLocker, which basically forms the pivot of a paperless governance, what it does is that since it is a central repository of a user's every important relevant document, whenever a requester is asking a user to authenticate the document, these documents are already there in the portal. And secondly, with the simultaneous authentication and approval by the user and the issuer, the third party requester will be able to access the relevant documents, and that is what has been there. So bank will be able to look into the various relevant documents which are important and necessary so as to provide the user the appropriate credit which the user is looking for. This is the stakeholder ecosystem, which is ultimately the foundational element of the functioning of DigiLocker. Now, what kind of benefits is it providing to the individuals? So, the first benefit is all the access and storing is based on the consent of the user, and no data and no document of that particular user will be used in any other ways without the proper consent of the user. And every data is secured in such a way that no third party or issuer agency will be able to access the user's data without the user's consent. Second is it is having a fully secure access. So as we already seen in the process of how do we actually utilize the DigiLocker, so it ultimately allows the user to use the facilities provided by the DigiLocker only when they set up their own account, which has to be guarded by biometric authentication or Aadhaar authentication, and it has to be set up with a PIN or a secret PIN. So ultimately it is extremely secure. Thirdly, since ultimately we are living in an era of internet and digital age, and all the documents that we want, and it might be helpful for us if it is stored at a central repository and if it can be accessed anywhere and anytime, what can be better than that? And lastly, since it promotes a paperless governance and a paperless environment, it has a much more positive externality for the environment as well, because it will result into saving of a lot of carbon dioxide emissions as well. And these are the set of benefits which DigiLocker actually provides to the users. But what about the other stakeholders? The stakeholders of issuers or requesters. So as we know that issuers, whether be it the issuers of called the banks or whether be it the third party fintech elements, the fintech wants to provide credit to the users, or any banks want to provide credit to the users, but there is a lot of time wastage in the process of physical interaction and verification of the documents by the users and the banking facilities. And by providing a central repository whereby users' content, every document is visible to the requester or the banking or financial technology sector in this particular case, the entire processes goes extremely seamless, and it results into a saving of lot of time, energy and financial resources, not only of users only, but also of the banks and other issuer organizations. But we need to make sure that since every user is trying to store their data within the DigiLocker ecosystem, but how secure is that DigiLocker ecosystem? And that is what we are going to discuss in the next section. So first of all, the DigiLocker uses a technology called encryption. That is the first point of how it ensures and maintain the security, that whenever the document is uploaded in the DigiLocker portal or ecosystem, it encrypts that particular document in such a way that had it been there any theft or any kind of nefarious activity over the server, the entire document will not be able to, the nefarious elements will not be able to access that particular document because of the end-to-end encryption. And the same technology is used in our day-to-day lives when we message our friends over WhatsApp. So you must have noticed that whenever you send any message to one of your friends over the WhatsApp, it is written over there that the message is end-to-end encrypted. And similar kind of encryption technology has been utilized by the DigiLocker. Second important thing is the DigiLocker is utilizing is the multi-factor authentication. Multi-factor authentication. What do we mean by that? Is that ultimately your documents will be authenticated and your identity will be authenticated not only based on only one factor but based on multiple factors. For example, since they are also taking your Aadhaar number, they are also taking your biometric details, and thirdly they are taking or asking the users to create their own PIN. So when all these three documents fall in line and there is a convergence between these three documents, then only there will be a proper authentication of that particular document, which basically creates an ecosystem of safety and security for the documents which have been uploaded in the DigiLocker ecosystem. And thirdly, it provides for a timed logout, which means that as soon as a basic minimal amount of threshold time has elapsed, the DigiLocker user account will automatically get logged out. And fourthly, in the rules which governs the functioning of the DigiLocker, it has been provided that there has to be a regular security audits by the firms which are empaneled with the CERT in, that is the Computer Emergency Response Team of India, okay, which is basically the nodal body for looking into any kind of cyber threats which is occurring in our country. Now, since it is from the relevant discussion, we can see that the DigiLocker and the facilities it is providing, it is quite secure. But what are the major issues which is facing its functioning? So the first issue that we need to discuss is the digital divide. And digital divide happens because of two things. First of all, low resources, that the poor people might not be having appropriate mobile phones or smartphones so that they can also store their relevant documents in the DigiLocker. And secondly, there are certain category of people that they have money but they don't have that relevant and requisite digital literacy, so that they will never know how to actually utilize the app, and this forms the major hurdle with respect to the functioning of DigiLocker. The second is digital exclusion. Imagine a situation, to understand digital exclusion, imagine a situation that a person has already uploaded their relevant important documents in the DigiLocker. But what happened is that one of the authenticating factor, that their Aadhaar number got changed, or their biometric details like their fingerprints got changed, and because of that that particular users are not able to access their relevant documents, and this leads to an institutional exclusion of people even when they have been enrolled in the DigiLocker facility. Such kind of things are very common with respect to our midday meal facilities also, where the Bal Aadhaar, that is the Aadhaar facilities which is available for the children who are enrolled in the school. So what happens is that most of the times because of the playing or any kind of rugged physical activity, the fingerprints keep on changing, or it changes a little, so that the biometric device which is being used does not actually identify those particular individuals, which leads to exclusion of such students in the particular school while availing the midday meals which are available in the school. And thirdly is that there is no uniform SOP among the governmental agencies. There is no uniform SOP among the governmental agencies, that there is no law which actually mandates that every government has to allow every citizen to provide both the physical and the e-documents or the digital documents. So since there is no mandate as such, there is no uniformity of law with respect to that, it creates a difficulty for the citizens to adopt in a greater quantity the usage of DigiLocker. So this is all for this topic. So recently, international non-profit organization by the name of Reporters Sans Frontiers, that is RSF, in English it is called Reporters Without Borders, and its French term is Reporters Sans Frontiers. It is an international non-profit organization working in the field of advocacy, promotion and defending of right to information and to promote the press freedom. So this RSF, hence we will be calling it RSF. So this RSF recently released the 2024 World Press Freedom Index, which is the 2024 version of the World Press Freedom Index, and this report has been published annually only. And what is the function and what is the objective behind releasing such kind of report? So this RSF, or Reporters Sans Frontiers, or Reporters Without Borders, one of the primary objective for releasing this 2024 World Press Freedom Index is that this particular organization tries to monitor and evaluate the status of freedom and autonomy enjoyed by the media, not only in numerous countries but across the world. So roughly in identifying and evaluating and calculating this index, this RSF, or Reporters Without Borders, they calculate and measure data from almost 180 countries, and at the end of every year they try to come up with one very holistic report covering the status of press freedom which is being prevalent in every country. So before we go on and discuss the various findings of the reports about the world, the regions, and our own country, which is India, let's try to find out and let's try to discuss the major roles which are played by the media in our society. So in a democratic society, one of the foundational roles which a media has to play is to keep the citizens informed. So we need to keep the citizens informed, or the media has to keep the citizens informed. Informed about what? Informed about the agendas of the government. Agendas of the government. Informed about various social evils which are present in our society. Informed about various good things. Various hope spots, let's call it hope spots, which are occurring in our society, which is acting as a precedent for others and a role models for others. So this is the primary function which a media has to perform in a democratic society. Second is, the second important role which the media has to play is to act as a watchdog. So media has a primary responsibility over acting as a watchdog to monitor the functions of the political functionaries, whether they are involving in any corruption or any illegal activities or impropriety activities. So that is also one of the major important tasks of the media. Third is, it is a torch bearer of marginalized sections. It is the media's primary responsibility to get that diversity in their whatever information that they are reporting, is that it should have diverse perspectives and it should have the problems which are being faced by marginalized communities. For example, migrants. For example, women, or scheduled caste or scheduled tribe. So for your own learning, I will try to give you certain such specialized media agencies which actually specialize in reporting for such segmented classes of citizens. For example, there is a very important and beautiful press agency by the name of Behan Box, which specializes or comes up with information or development taking place with the women of our country. So about this portal called Behan Box talks about the various developmental parameters over which the women of our country are showing progresses, and what kind of parameters where women of our country are showing decline in the progress. And secondly, there is also a very important portal by the name of Pari portal, which is People's Archive of Rural India, and this portal basically provides information and news related to the rural distress which is prevalent in our country. And fourth point, the most important, is bringing in transparency and accountability. So that, as it is famously said, that one of the primary responsibility of media is to hold power to account. So it is the primary ethical and moral responsibility of the media to hold the powerful persons to accountable, to not only to the citizens but also to the other stakeholders of our society, whether it be it constitution, whether it be it our institutions, whether it be it civil society. So one of the major important function which the media has to play is to hold power to account, to hold the powerful persons or the political authorities to be accountable. By doing what? by bringing in more transparency with respect to how these political functionaries are functioning. And these are the major functions, or which are the major roles which the media has to play in a democratic society. But since this particular topic that we are going to deconstruct, it relates to World Press Freedom Index. So how do we, since we already know what is the primary role which the media has to play in our country or in any democratic society, but how do we define what is press freedom? So the definition of the task of providing the definition has been made easy by the Reporter Sans Frontiers only. So it has provided a very beautiful definition of press freedom, which says that it is the ability of journalist, either the journalist acting as an individual or as a collective body. So it can be an independent journalist or a freelancer journalist, or if it is a collective body, then it can be a media agency also, to report, to identify, produce. There are three aspects to it: to identify, produce, and thirdly, disseminate such information which are in public interest. But there is a rider, that the journalist, whether be it independent or collective, they should be able to identify what news they want to show. They should be able to gather more evidence so that they can produce it, and they should be able to disseminate the information also. They should be able to use various medias which are available over there to take that particular piece of information, which is very important from the public interest point of view, to the larger audience or to the citizens of our country. But there is a rider. But it should be independent of political, legal, economic, social interferences, and along with it, the physical and mental health of the journalist should be secured. So, as we know that the definition of press freedom is quite clear, and we should know that whenever the press or the media or the journalist, whether be it individual or collective, whenever they are functioning in the interest of the people, we should be able to see that the interference which is occurring and which is creating hurdle in providing appropriate delivery of services or delivery of information, such political, legal, economic, social interferences should be minimized in a country. So then only there will be an environment which is conducive where the press freedom can actually grow and flourish. And that is what we are going to discuss in the next section, is that what are the major areas of interference, as we already saw from the definition which has been provided by Reporters Without Borders, and ultimately we can also call it as the major threats which the media faces in functioning or providing relevant information to the citizens. So the first level of intervention is the political intervention itself. What do we mean by political interference? It means that the level of respect and autonomy media agencies enjoy vis-a-vis political authorities. For example, to understand it with the help of an example, we can say that how comfortable the political authorities of a country are with respect to media trying to actually uncover what kind of work these political authorities are doing. Are political authorities comfortable with those media houses? Is there any case of that whether the political authorities are only having a conversation with a certain segment of media and absolutely ignoring another segment of media? Such kind of activities by the political authorities and such kind of respect which the political authorities give to the media and the environment which the political authorities create for the media to flourish and function, it is called the political aspects of interference or the political threats which the media faces. Now, what kind of legal threats does the media faces? So ultimately, there are various kind of laws and acts which are actually instituted by the political authorities and the institutions, which actually diminish the functioning or the press freedom in any particular country. For example, cinematograph Graph Act of India of 1952. It provides for censorship. Secondly, there are many draconian laws, draconian sections of IT Act of 2000. And there are also relevant sections of CRPC and IPC, which actually provides a gagging effect on the media. So these are the various kind of legal interferences which a media faces in their day-to-day functioning. What about the economic interferences which any media agency might face? So there are various examples to understand it with the help of an example. There can be a certain cases where all the government ads and revenues are going only to few of the media agencies and not to the rest. It is very much visible in our Indian political system also, that the government is very comfortable in speaking to certain set of media and is providing all the advertisement revenues to only a handful of media agencies, and the majority of the media agencies are left without anything. So these media agencies which are taking the benefit of the advertisement revenues from the government, they have to do some quid pro quo. So these media agencies act as a spokesperson of the government itself, and which is going absolutely against the media ethics. And secondly, about the ownership pattern, it is also a very stark reality in our country that only few important big business houses in our country are holding a lot of media agencies, which again hinders the free functioning of the media and its autonomy. Apart from it, what are the socio-cultural hinders that we faces? So, as we know that our society is quite orthodox, and the customs and the religious customs that we follow are very deeply embedded in the social psyche or the social cognition of our society. So ultimately, whenever a media agency or any independent journalist tries to challenge the existing norms and customs of our society, which are discriminatory in nature, for example, let's take the case of LGBTQ. So if any journalist is trying to cover the issues faced by the persons of LGBTQ community, or if they are promoting the rights for the LGBTQ community, such kind of journalists are threatened or intimidated by various social forces, and these kind of interferences are called the socio-cultural interferences which the media has to face. And lastly, it is not an uncommon occurrence in India that the physical safety of various journalists is also threatened, and especially the journalists who are working in certain conflict regions like J&K or areas infested with left-wing extremism. So it has been informed various times in various press and media agencies that the journalists which have been working in such conflict regions are being threatened and physically harassed and molested. So it is a very starking situation for the press to function in a more and free and fair manner. And let us try to come to understand the various findings which the World Press Freedom Index has provided. So this is the map. It's a heat map which has been provided by the Reporters Without Borders across the world. So as it is quite visible that these areas which are found in the green color are one of the best countries for the media to function. That these people, the countries of Norway, Sweden, Finland, they are enjoying the maximum of the autonomy with respect to their functioning. However, there are certain countries like Eritrea and the major Maghreb and Middle East region. These are the worst regions of the world with respect to functioning of the media and the status of press freedom which is enjoyed by the media agencies in this particular region. And the detail of such things we will be covering in the coming slide. So let's try to find out what does the result say about the position of our own country with respect to the year of 2024. So in the year of 2024, India gained 2 places and came to a rank of 159 out of 180 countries. And the same rank was in the year of 2023 was 161. So definitely we can see there is an improvement of 2 ranks. However, one important aspect we need to note over here is that whenever the Reporters Without Borders or the World Press Freedom Index, whenever it evaluates the level of press freedom in any country, it scores it within the range of 0 to 100 marks. 100 being a country having most free environment for the press to function and 0 being the worst case. So, although India gained 2 ranks in year 2024 with respect to the previous year, however, there has been a 4-point decline in the absolute score. So, which means that relatively India has performed better as compared to the other countries. However, in an absolute terms, there have been a 4-point decrease, and especially in the political interference zone. Especially in the political interference, and the World Press Freedom Index has noted that the Indian political environment is very dangerous for the press freedom and the physical and mental safety of the professionals which are involved in the media agencies. Now, important point to note over here is that India is ranked at 159. Now, among our neighbors present in the South Asia, it is only the Bangladesh which is inferior to our country, and even countries like Pakistan is above our country in the realm of press freedom. So we can understand what kind of adverse adverse performance we as a country have shown in the World Press Freedom Index. However, if we need to compare our performance temporally, we need to identify that since 2003, almost since 2003, our press freedom index or the scores that we are getting in the World Press Freedom Index has been showing a persistent decline, and there has been a significant decline since 2014. And the major important points which the World Press Freedom Index has highlighted for our own country is that it has highlighted that there has been an undeclared state of emergency. Undeclared state of emergency for the media professionals, and it has provided the major reasons for telling that India is facing an undeclared state of media emergency is that there has been an increasing consolidation of the ownership pattern vis-a-vis the major industrial houses of our country. So only handful of mega industrial houses of our country owns a lot of media agencies in our country, which actually hinders and admonishes the press freedom which is available to them. Press freedom which is available. And if India seriously wants to go towards becoming a developed country, and it aspires to perform very well in other developmental parameters as well, press freedom is one of the most fundamental aspects for any democracy, since it is only the freedom of expression which gives this marvelous political system which is known as democracy its major strength, that every individual or every citizen, however powerless he or she may be, should have that freedom of expression to express whatever they are feeling about the political authorities of our country. Now, as we recently finished the general elections to constitute the 18th Lok Sabha, it was widely observed that even after various advisories by the Election Commission of India, various political parties very consciously broke the model code of conduct. And it was very highly debated in our society that whether the Election Commission does not hold the powers to deregister and de-recognize the parties for the violation of MCC. And this is what we are going to discuss in the coming section. So, to begin the major discussion, let us try to build our discussion from the definition of a political party. So, what do we understand by a political party? So, political party is nothing but a voluntary association or a organized group of people. Organized group of people having similar agendas, ideologies, or political interest. And these voluntary associations or organized group of people, they want to participate in the elections to gain the political power to run the affairs of the country. Now, there are numerous voluntary associations in our country having similar ideology, similar mindsets and similar political interest, but many voluntary associations, they do not want to capture power to run the affairs of the country. However, certain voluntary associations, they actually want to participate in the constitutionally mandated electoral processes of our country, and then to legitimately gain the powers which has been provided by the constitution to run the affairs of the country. Now, the one question emerges: can any voluntary association contest elections in our country? So the answer is absolutely no. So as soon as a voluntary association wants to contest elections in our country, it needs to get itself registered with the Election Commission of India, and then this voluntary association will be called as a political party. So before it is getting registered with the Election Commission of India, it will not be labeled as a political party. Rather, it will be labeled as a voluntary association only. However, the section 29A of the RP Act 1951 deals with the process of registration of the political parties. It says that whenever a voluntary association wants to get itself registered with the Election Commission of India, it wants to do basically two things. Section 29A asks the particular voluntary association to submit a copy of their memorandum or the copy of the constitution of the party with the Election Commission of India. And secondly, this particular voluntary association should bear true allegiance to the Indian Constitution. So whenever these two conditions are fulfilled, any voluntary agency can be registered by the Election Commission of India as a political party, and now this political party will be able to contest elections. Why I am trying to discuss this process of registration? Because there is always a confusion among the students with respect to the two different processes. One is getting registered, which we already discussed, which is dealt by the section 29A of the RPA, and another is getting recognized. So what is that process of getting recognition? Now, as we already know that whenever a political party is registered with the Election Commission of India, now they can contest elections, and based on the performance of the poll or based on the performance of the political party when it contested certain elections, Election Commission of India provides a certain categorization which is it called as recognized parties, and it recognizes those political parties as national party and state parties. Right now we are having 6 national parties in our country and 61 state parties, and this recognition is provided based on the performance of the political party which it has exhibited in contesting various elections. So this recognition is only provided to the political parties who have performed better, and the political parties which do not get any recognition as state or national parties, these are called as registered but unrecognized political parties, or RUPP. Okay, so with respect to our country, roughly with respect to the registered political parties of our country, they are roughly 2,000, approximately roughly 2,800 political parties functioning in our country. As we already discussed, there are national parties which amounts to 6 and state parties which amounts to 61 state parties which are functioning in our country. Now, what kind of benefits does a political party or a voluntary association gets once it is getting registered as a political party with the Election Commission of India? So firstly, it provides for allotment of party symbol which can be used across elections. Secondly, it provides for income tax exemptions to the registered political parties under section 13A of Income Tax Act of 1961. This is a major important point or the benefit which is being accrued by the political parties in our country. And thirdly, it provides for provisions of star campaigners, and fourthly, it provides for time slots in public broadcasting during the campaigning of elections. Now, these are the major benefits which are being accrued by the political parties once they get registered with the Election Commission of India. Now, we need to understand that apart from the major topic or the major agenda of the discussion within this topic was that the political parties was found to be violating the model code of conduct very consciously even after Election Commission of India was advising against it. So this is what we are going to discuss over here. So what kind of like issues we are facing with the political parties over here. So what kind of issues we are facing with the political parties? First of all, non-compliance with model code of conduct. This topic we already discussed in quite depth in the month of April also. Second, not all parties are contesting election. As we already noticed that we have roughly 2,800 political parties, but not all parties are contesting elections. Only a handful or a minuscule proportion of the political parties registered in our country are contesting elections. It is leading to unnecessary administrative load on the Election Commission of India, and it is absolutely a fox pass on the Election Commission of India. And thirdly, it is acting as a media of money laundering. Acting as a media and mode of money laundering. How? Because as we know that the registered political parties in our country are getting income tax exemptions, and these political parties are taking donations from various individuals, whether be it businesses or individual taxpayers, and then they are returning it and layering the money so that they are able to launder the money. With respect to that, both the parties are able to take benefit of that flaw which is pertaining in the Income Tax Act. And because of these things, there has been an increased debate in the society that since Constitution and the relevant laws, which is the Representation of People Act 1951, since it provides the power to the Election Commission of India to register the various political parties, so why the RPA and the Constitution does not provide the same power to Election Commission of India to deregister it? So let us try to see what the Election Commission of India can do with respect to such cases of gross violations of Model Code of Conduct, or whether can the Election Commission of India deregister or derecognize the parties. And this is what we are going to discuss in this section. So first of all, let's try to see under what conditions can Election Commission of India can deregister a political party. So we need to identify one important, very important point over here, that the RPA or the Representation of People Act 1951 is silent on this thing, is silent on this front. So RPA does not provide any power to the Election Commission of India to deregister any political party. However, Election Commission of India can deregister a political party under two circumstances. First of all, it identifies that the concerned political party is not showing true allegiance to the constitution of our country. And secondly, under the request of central government, if the central government identifies any political party to be unlawful. And central government can do this under the Act of UAPA. So central government is very well empowered by the provisions of UAPA so that it can define any voluntary association to be unlawful in nature. And if central government declares this to be unlawful, Election Commission of India, then it will be obligated to deregister that particular political party. For example, there is one body by the name of Popular Front of India. Popular Front of India. This was basically declared unlawful by the government of India using the provisions of UAPA, and it was deregistered by the Election Commission of India. Now, coming to the second aspect of derecognition. So, if we'll understand that the recognition provided to the political parties, first of all, was based on the performance which the political party has exhibited in various elections. So, the first point is the Election Commission will be able to derecognize a political party or suspend or withdraw the recognition given to a particular party, whether be it national party or a state party. So, under two conditions. So, first of all, if it identifies that the particular national party or state political party is not able to fulfill the basic minimum criteria. Basic criteria to be categorized as national party or state party. Second important point to note over here is that the para 16A of election symbols order of 1968, this is the only legal instrument which provides that the election commission can suspend or revoke, suspend or withdraw recognition to a political party, under two conditions: if it violates the MCC or the Model Code of Conduct, and secondly, if the political party fails to follow the lawful directions given by the Election Commission of India. And this power under the rules 16A of the election symbols reservation and allotment orders 1968 was utilized by the Election Commission of India to suspend the recognition of state party given to a National People's Party. So for time being, it had suspended the the recognition status of state party given to this particular political party. So since this had been a proper issue with respect to how election commission should manage such kind of things, what legal and institutional precedents do we have? What kind of committees, what different committees have suggested in this regard? So you will be surprised to know that from the year of 2002 till 2016, so there was a committee by the name of National Commission for Reviewing the Working of Constitution. Along with that, in 2015, there was a law commission, that is the 255th Law Commission report on electoral reforms. And in 2016, Election Commission of India released a memorandum of electoral reforms. In these three major documents, all the experts and political experts have suggested that the Election Commission of India should be given the due power with appropriate amendment to the relevant legislations, whether be it constitutions or the Representation of People Act of 1951, and that the Election Commission of India should be provided the authoritative power to actually deregister and derecognize any political parties if it feels that there has been a gross violation of Model Code of Conduct.